He's Eric Kolder with a folder in the background, which is terrific. We are talking about the 2021 labor law update. And let me tell you a little bit about Eric and why we should listen here. Eric is a shareholder at a firm called Ramey Flock, and they are here in Tyler, Texas. He focuses on employment law, litigation, estate guardianship, commercial litigation, and employment law practices. So you will not find anybody more educated on the subject of which we're talking about today than Eric. He is a graduate of both Louisiana State University, commonly known as LSU, and the University of Texas Law School. So Eric, I'm going to do my best to make the technology work here. So I'm going to stop my share. If you will go ahead and start your presentation, and we will get started immediately.
All right, thanks, Coleman. Let me see if I think we have it. All right, now we're going, it looks like. So thanks for the introduction. Appreciate it. And for those attending, I know that there's some folks not from Texas. I'll try to highlight which things are Texas specific and which things are applicable to all. So again, thanks for the opportunity, and let's get started. Let's see. So here's the kind of an outline of what we're going to cover in this presentation. So first, we'll get the COVID related things out of the way. Everybody's sort of sick of hearing about COVID and COVID regulations and everything like that. Some of these things are falling away and expiring, so that's a good thing to sort of get back to normal. But we'll cover what we need to know from this point forward. All these things listed here. So the FFCRA, OSHA, the CDC, workers' comp, again, that'll be more Texas specific, ADA, FMLA, and the vaccine. That's one thing that's new now that wasn't the case in 2020. We can talk about what employers need to know and what they need to do about the vaccines that are available. Then we're going to get into some case law, which is always interesting because it's a review of the principles that we need to be applying as employers. And just to reiterate, I represent mainly employers. Over 95% of my practice is representing employers in employment law, both compliance and in litigation. So I see on the front end how we can prevent, and I see on the back end how things can go wrong or how things go right. People sue you and you prevail, get the case dismissed, and then you realize you did the right thing all along. So I have some good advice on that, and some good case examples from Texas and the Fifth Circuit from federal and state courts about the items listed there. Obviously, trade secret litigation will be more of a Texas specific thing because those laws vary from state to state. But most of the others will be applicable to all the states. So let's start with COVID related issues first. So the big one is the Family First Coronavirus Relief Act, which was passed at the very beginning of the pandemic in 2020. And as I'm sure everybody on this call knows, that it was applicable to basically all employers. Unlike most federal legislation, it applied to basically everyone. It was oddly drafted, and it said that if you had under 500 employees, well, that's basically everyone with a few exceptions if you do the percentages of employers of that size. So it applied to everyone, and as we all know, it allowed paid, or actually required, mandated paid sick leave for employees for up to 10 days or 80 hours for 5 enumerated COVID-related reasons. There was a 6th reason that said whatever the Department of Labor adds to it, and they never did. So it just stayed basically at 5 reasons. Now that has expired as of December 31st of 2020. So that has expired. It's no longer required. And if you remember the reasons, it was if you were ordered to quarantine by the government or by a healthcare professional, or if you were symptomatic and seeking a diagnosis, if you were helping care for someone who had tested positive and was staying home, or if you were caring for a child whose daycare or school was closed due to COVID reasons. And that was all required last year. And you would, if you granted the leave, which you had to, then you would get it reimbursed by the government, by the federal government, when your payroll taxes, your quarterly payroll taxes. So it didn't lead to too many disputes. It led to some compliance questions along the way. It wasn't very contentious in my experience. Obviously, all my clients had to deal with it. There was a few gray areas. Some people maybe trying to test the rules a little bit, but it really wasn't that bad. And the main reason is, I think, is because it was reimbursed by the government. So it really wasn't that dangerous to grant the leave if it fell within one of the categories. And from the feedback I've gotten, the IRS has not been very strict or nitpicky when it comes to allowing the reimbursement. So
Eric, I'm going to interrupt you real quick. I believe some folks have caught up in the chat. I believe that expired 2020 and not yet 2021.
Oh, yeah, sorry, that's a typo. In my notes, I have 2020. I have it here.
Our eagle eye, very keen viewers noticed that. So there you go.
Yes, that's correct. I'm sorry. I have my notes here. It's correct 2020, and it's not applicable as of January 1 of 2021. Now, what has been expanded though in the new bill that was just passed last week. So it isn't required. It still is not required, but it's optional. So you can grant paid leave to your employees for those reasons, and they even added a few more reasons about getting a vaccine or waiting test results from a COVID test, that sort of thing. So there's more reasons now, and it originally was extended at the very end of last year, optional, to the end of first quarter 2021, which means that if you did grant that type of leave, you could be reimbursed. Now, the new bill passed last week, it extends it through the third quarter of 2021. Again, optional. It's still 10 days, 80 hours, and you can be reimbursed. So that's a good thing. It's optional. If you're doing it, be sure to keep records of it and apply for reimbursement. So it's not required, but it is optional. The required portion all expired as of the end of last year and the end of 2020. Also, the new bill added some new or continued some unemployment benefits, some federal help for state unemployment benefits. It extended the time and the extra federal money that goes toward people on unemployment. So that was one change in the bill last week. But overall, FFCRA expired, not applicable. You can comply with it if you want to until third quarter of this year and still get reimbursed. So if you're doing it, record keep and get reimbursed. If not, you don't have to worry about it. You're not mandated to do it. Now, OSHA has, if you remember from last year, I'm sure you do, that it was sort of a tiered situation where depending on what type of business you have, depends on what kind of risk you have as far as the virus, and they made some recommendations. So I would review the current recommendations applicable to your business and do your best, of course, to comply with them. Now, we did a presentation last, I believe it was in June, about various COVID-related things in the workplace. And Coleman maybe will post a link to that presentation in last summer. From last summer, and we covered more of the details about that. That is still roughly the same. It's changed a little bit since then, but the key thing to worry about with OSHA is obviously a citation. They haven't been very aggressive, at least under the prior administration, citing anyone for not following those. But here's what does come up, and I've seen this come up a few times, is the idea of OSHA retaliation. So here's how that works. You have an employee that comes forward and says, I think this is unsafe because of this reason. And it may be because, hey, I read the OSHA regs or I saw a news story about it, and I think we should be having this either everybody PPE or everybody distance or whatever the practice is, and they complain to the employer, and the employer may not agree with them or may look, I've had it happen where we looked it up. It's like, well, no, actually, we're in compliance. And so thank you for your concern, employee, but you have to comply with what our rules are because they're complying with OSHA. Now, that person maybe will still disagree. Here's a situation for the employer, though, is that we can't, as employers, take adverse action against that employee for making that sort of a complaint. But the good news for employers is that if the employee feels that they have been retaliated against based on an OSHA complaint or a workplace safety complaint, because remember, OSHA, the general duty requirement applies to all of us to maintain a safe working environment, the general duty. And if they make a complaint and they feel like they've been retaliated against, they only have 30 days. That's a very short time in the realm of law to actually bring the complaint to OSHA, not EEOC, to OSHA. And they don't have a private right of action, which means they can't hire an attorney and sue you based on it. They have to go through OSHA only, and they only have 30 days from the action. And it came out this way one time with an employer last year, which is a group of employees made a complaint about safety. They did make they were fired because they actually walked the job and said, we don't think it's safe, we're going home. So they walked the job and the employer said, fine, well, then you quit, I guess. Well, they filed an OSHA retaliation claim. OSHA looks at it, they investigate with them. I represent the employer in the investigation, came back and said, here's what happened. And here's the good thing for employers is that the employee, though they voice a safety concern, even if they're right, or even if they're right, if it's not to the point where their life is in danger, they generally can't quit or walk the job. They can't just leave unless it's that serious. And so they left, and even if they were right, it wasn't a life or death situation, and therefore it wasn't that serious. And the OSHA found that the employer, the client, did not retaliate, and that the employee was not justified in walking the job, and they quit the job. So OSHA investigates it, but just be mindful of that. Be mindful of that if somebody's going to complain about what they don't think is safe or not, at least look into it and get back with the employee. And then kind of be careful with how you treat them after that, because depending on their demeanor and how they bring the complaint, like in the case I'm talking about, the employer wasn't very upset that they had quit because they were quite obnoxious about it. I know that's not normally the case, but it can be. But just be careful when they make complaints, because you don't want to open yourself up to a retaliation claim under OSHA. Now, next is the CDC recommendations. As you guys know, those aren't really binding. You can't be fined or by the government. They're not mandatory. OSHA is more of a mandatory thing. CDC's recommendations. Now they're good to follow. Now first of all, they change periodically. So keep yourself updated on what they recommend. That's probably changed more than anything else regarding COVID since it started as a CDC recommendation. So follow them, keep up to date with them. They're not technically binding, like I said, but it could open you up to another type of claim here, which would be, for instance, a customer or a vendor coming in. If you are not following the CDC recommendations and this is hard to prove, but if they get COVID because of that, and they can show more likely than not they got it at your place of business and you weren't following the CDC guidelines, there you could have a claim of negligence, right? I'm coming onto your property. You have an operation going on there. You're negligent in the way you're conducting it, and I got injured, in this case, sick with COVID because of it. And evidence that you're violating the CDC recommendations can be evidence of negligence. So it's not direct, it's indirect, but it's still a real possible risk. Again, it'd be hard to prove that someone coming to your facility got it there and it's because you weren't following the protocols. So it's more of a paranoid lawyer worry, but it's still something to consider and why you should maybe keep up with the CDC recommendations. Next is workers' comp. So again, this is a Texas specific. I don't know much about really anything about other states' workers' comp laws. I imagine they're similar in certain ways, maybe not the non-subscriber thing we're going to talk about in a minute, but this part's probably pretty similar. And does workers' comp cover COVID? We had, again, the presentation from last June, I believe it was, covered this in depth. But the issue is, think of it this way. I have occupational disease or ordinary disease of life is the full term there. So workers' comp doesn't cover ordinary diseases of life, things you just get from being alive or being in society, but it does cover occupational diseases. Now, COVID may be an occupational disease for some businesses, but not others. So generally like healthcare, maybe retail even, it could be occupational disease that basically because you do this type of work in this environment, you are more susceptible to contracting the virus. You'd have to show that that's true, it's an occupational disease, and that you got it at work to have a workers' comp claim. But for employers, you don't mind if it's a workers' comp claim because it's going to be covered by your insurance, and that's fine. I think for the vast majority of businesses, though, it's going to be an ordinary disease of life, sort of like the flu, and it probably wouldn't be covered by workers' comp. But that's just something to think about when it comes to those type of claims. I don't know how many people have had that come up where employee thinks they got it at work and what the carrier argued about that, whether they argued ordinary disease of life or occupational disease. But that's still in play, right? I mean, as long as COVID's around, that issue is still in play for a workers' comp perspective. That's not going to expire as long as the disease is around. So does your business lead to a greater degree of risk for the employee? Most of the time, no. Offices, normal businesses, it wouldn't be. Maybe retail, maybe healthcare, but not a huge worry, but something to be mindful of. Now, the vaccine. Here's the big thing that's new that is on employers' minds. So first thing is you generally can require your employees to get the vaccine. That's number one. There's plenty of businesses that have required different vaccines for a long time. The measles, mumps, rubella vaccine, or the flu vaccine, for instance. There's certain employers that will require that. And that's, in general, that's okay. However, you want to be mindful of two big exceptions to that. Number one, and this is the big one, is the Americans with Disabilities Act. If the employee has a disability that would put them in greater danger with the vaccine, where they're like, for instance, their doctor says, hey, because you have this condition, I don't recommend you get the vaccine. It's one example. Then that person is protected if they have a disability. Now, again, under the ADA and the subsequent amendments to it, what is a disability can be quite broad and sometimes surprising. So the basic definition is that you have a health condition or physical or mental health condition that affects one or more major life activities. And all of those things are defined quite broadly. So if that's the case, and I have a doctor recommendation, I should not have the vaccine, I go to my employer, what is your duty? Your duty as the employer is to discuss, it's called interactive process in the statute and the case law, but that just means have a two-way discussion about what can be done. Is there a reasonable accommodation that can be made for this employee to fulfill the essential functions of their job? Now, again, what would that look like? More than likely, it's going to be teleworking, additional PPE for this person, maybe distancing them, putting them in a different area at work to keep them more separated from other employees. Those are things that are accommodations. And we're going to talk about a good case that came down this year that illustrates this important point, is that though you're discussing accommodations with an employee, the employee does not get to decide which reasonable accommodation they get. It's actually the employer's choice. So if they propose one and the employee proposes one, or you discuss 3 or 4, it's the employer's choice among the reasonable accommodations that is required. The employer doesn't get to choose whichever one it wants. You get to choose as employer. And there's a good case, that they're very good finding on that issue. So have the interactive process. Now, sometimes it's possible where there is a reasonable accommodation. I'm not sure what that would be in this situation with the vaccine, but sometimes there are no available accommodations. In that case, you don't have an obligation to keep them employed. That is rarely the case. It can happen. The one I always use is I had a case with an epileptic crane operator. Well, there was no accommodation we can make for the guy. And so he had to resign basically once he realized the issue. He didn't disclose it. And once he did, that's very rare though. Normally there's an accommodation. So that's ADA. Do they have a disability? If so, discuss accommodations, generally telework, PPE, that sort of thing. The other one is much more unlikely. And that is, I have Title VII there. So Title VII refers to the Civil Rights Act and specifically religion. So Civil Rights Act prevents discrimination based on race, sex, religion, national origin, etc. Well, the one about religion is relevant here because if you have a bona fide religious objection, to it, as based on tenet of your faith, then you can be entitled to a reasonable accommodation. But the reasonable accommodation in the context of religious discrimination is much different and much less onerous than under the ADA. It's the same word, but it's actually the same words, but used differently. So here, you don't have to merely take the employee's word for it, by the way. I've seen a lot of people that are hesitant for the vaccine, and maybe for good reasons, maybe not, but I haven't seen anyone making a true religious argument. It's a medical argument saying, I don't think it's safe, I don't trust it. Fair enough, that isn't protected under either one of these. I just don't think it's safe. Well, that's not because of your disability, and that's not because of your religion. That's just an honest, assessment you're making. So if you don't like it, you can work somewhere else at that point. If you want to have that hard of a stance, you don't have to, but you can. So here's the thing: is that it's kind of hard to imagine. I know there's some potential out there for a few of them where a religious tenet of someone's faith would prevent them from getting this vaccine. It's possible. Have the discussion with the employee if that's the case, and if it is the case, then you have a duty to make a reasonable accommodation. However, the standard is so low, it's basically anything more than a de minimis burden on the employer. They can forbid the accommodation. I'm not saying you want to do that, but you're not as bound as you were under the ADA for that. So if somebody brings it to you, hear them out. There was a Third Circuit case that dealt with this about a flu vaccine. Employee said, I didn't want to take the flu vaccine. It's a religious objection. Case was dismissed, went up on appeal. The Third Circuit said, yeah, the employee's complaint was really a medical objection, not a religious objection. And that's probably what's going to be more the case here. And that wasn't protected. Religious objection is, a medical reason is actually not. Under the ADA, when it comes to COVID, most of the cases, probably 90+% of the cases would not be considered a disability under the ADA. However, there are people who have longer term effects and have complications that continue on for many months after contracting the virus. I have someone I know, for instance, and he's a early 50s guy, and he was pretty healthy, but he's still suffering months later from debilitating effects of it, where he has to have an oxygen machine at home, et cetera. And so that would naturally affect his ability to go back to work. In that case, it would be possibly a disability on ADA, and an accommodation might be needed. And so most of the COVID cases won't qualify. Some will. If they do, and they're longer term and it's more debilitating, what kind of accommodations might be necessary? Well, one of them is unpaid leave for a specific amount of time. That can be reasonable, or a flexible schedule, or there's various things depending on the person's condition. So don't automatically assume COVID is not a disability. Sometimes it can be if it's longer term, more serious, but also know that almost the vast majority of times, COVID will not be considered a disability under the ADA because it just doesn't meet the standard that it needs to. FMLA, same sort of thing. Now, FMLA only applies to businesses with 50 or more employees in a 75-mile radius. Now, that is not many employees. It's like under 5% of employers nationwide, I think, or maybe in Texas. So this isn't actually that many businesses, but if you do have 50 or more employees, you probably are complying with FMLA. And if you're not, you need to start, of course. But treat COVID like everything else under FMLA, unless you're voluntarily doing the FFCRA extension. But let's just talk about FMLA. Obviously, sometimes COVID can be considered a serious health condition that makes an employee unable to work for a few days, and it might qualify for FMLA coverage. Now, if it is, go through your normal process. If you require certification, do it. Send the notices that you have to. Keep track of their time taken, et cetera. Don't interfere with them when they're on FMLA leave, that sort of thing. Certainly don't retaliate because they have to take FMLA leave. But again, if you have 50 or more employees, COVID certainly can be a serious health condition that justifies FMLA leave. If it does, be sure to comply. just treat it like everything else, basically, at this point. Nothing special, but just treat it like every other illness an employee may have. So next, we'll do the case law update. And again, I hat tip to the State Board of Texas Labor and Employment section. They have great summaries and updates for us about the latest goings on in case law. So we're going to go through that. Thanks to them for that. So I don't have this on the slide, but we had done a newsletter about this at work and I'm sure you all saw it on the news, which is the big Supreme Court case that came down last summer about homosexuality and transgender status being protected classes under the Civil Rights Act. So I didn't put that up here, but I mean, you guys probably already complying with that federally now in every state, homosexual status and transgender status are considered protected classes. You can't discriminate and harass based on that. And it falls under the category of sex. I know the Equality Act, which I don't think is going to pass, but they want to add it specifically as its own category. But the Supreme Court said that those two categories fall under because of sex discrimination. So obviously in your handbooks and your policies, you treat people based on their sexual orientation and their transgender status is protected under the Civil Rights Act. And that's in every state. That's a federal law, Supreme Court of the United States. So I didn't put that on there, but I'm sure we all have probably done our due diligence on that one. So here, the first one is interesting. It's an Eglin case. Again, this is a federal case that went up to the Fifth Circuit. And it's interesting. So, you know, as an employer, we worry about things about like stray remarks, things that supervisors say that get us in trouble. And sometimes we may overreact to how bad the statements are. So for instance, in this case, a supervisor told the certain employees that the company was going to replace Black employees with Hispanic employees. Now, the court found that this was not direct evidence of discriminatory intent. And you say, well, that's kind of strange, right? I mean, these guys feel like they're discriminated against. And you had a supervisor of the company saying, well, telling them that the company wants to replace Black employees with Hispanic employees. But that's not the end of the story. The rest of the story is that supervisor that made those comments did not actually supervise the people who were complaining about it, who sued the company. So he was a supervisor, but he wasn't their supervisor. And more importantly, it was a female supervisor in this case. She didn't identify why she believed that, the source of her belief. So she was just talking off her head. She wasn't saying, hey, I talked to somebody on the executive committee and this is what they're going to do. She just said it. And the court said this is not direct evidence of discriminatory intent. So, of course, you don't want our supervisor saying anything silly like this. Even if they do, though, the plaintiff still has to be able to show that the comment was made by somebody who has some kind of power or knowledge. In this case, that supervisor didn't have any authority over these employees. And also, it wasn't based on any actual communication with somebody who actually had the authority to do what the person said that the company wanted to do. So good result for employers, but you don't want it to happen. But even if it does, the courts don't just stop there, of course. So that was a good result. Now, I did a newsletter on this a few months ago called the Cat's Paw Theory of Liability. It sounds pretty funny, right? Cat's paw, what is that talking about? It's some old, I don't want to say wives' tale, but it's like a parable about a monkey tricking a cat to grab something for the monkey. And so the cat gets in trouble, the cat gets hurt, and the monkey gets the peanuts, basically. And that's why it's called cat's paw. It's sort of strange. But the idea in the newsletter was even on this case specifically. So as an employer, here's something to consider, is that even though, let's say I'm the decision maker, I have no discriminatory intent with the decision I'm about to make with this employee, let's say letting someone go. But the supervisor of that employee who's reporting to me about this employee's bad performance or behavior, what if they have a bias against this person based on race, for instance, or age or religion, any one of these things? And I don't, but the supervisor does. He's reporting to me to get me to fire this other employee. Well, the company could be liable in that case. Under the Cats Paw Theory, the idea is that this biased employee is influencing the true decision maker to take action on behalf of the company. And the company can in those situations be liable based on the Cats Paw Theory, the idea that the biased employee is influencing the decision maker. Now here, they tried it. It did not work. Again, a Fifth Circuit case in federal court. Here, there was evidence that they put forward the evidence that there was someone that maybe had a bias against the employee who was fired, but other evidence showed that the decision maker made an independent decision based on his own investigation of the evidence. So for instance, in my example, the supervisor, in this case, the manager, is given the decision maker information, but the decision maker didn't just take the person's word for it. He did his own investigation, found the facts to be true, and terminated the employee. So it was tried. It's something to be mindful of. Especially if you have a complaint maybe about this manager being biased, and well, okay, I can't just take the word for it. I need to do my own investigation to make sure I can back up my decision. So it turned out okay, But that's a potential blind spot for employers, because you may think I'm the decision maker, I have no bias, no evidence of my bias at all. Well, the employee may be able to still get all the way to a jury in a case like that, which means not dismissed. It means it's a lot more costly, even if you win. Based on Cats Paw Theory, it's hard to win, it's hard to show, but be mindful of it as employers. And this is a good result, kind of demonstrating what the principle is and how it works, and how if you do everything right, you'll still be okay. In this case, the employer was okay. So next is, and this is a Texas case, but there's a federal version of this that applies to all employers. So when it comes to, for an employee to bring a discrimination or harassment lawsuit, they first have to go through either the state or federal government and file a charge of discrimination, giving the government notice, say, I think I've been discriminated against, look into this. The federal government generally gets 6 months to look into it, after which point the employee can then ask for permission to sue the employer in court. But they have to go through this process. If they don't do it, they can't sue. So it's a big deal. Now, they have in Texas, under state law, they have 180 days from the date of the incident to tell the government about it. Under federal law, it's 300 days. So that's the federal version of it, 300 days. This case was applying the Labor Code Chapter 21, which is 180 days in Texas, but the federal version is 300. But it's the same principle. Here, a lot of the things the person was complaining about happened well outside of the period of the 180-day period. But in this case, it was a continuing set of continuing violation is what it's called. So for example, if one employee is being sexually harassed by another and it goes on for months and months and months, then you can't say, oh, well, you missed your deadline because, hey, it wasn't 300 or 180 days from the incident. Of course, look and say, what's the most recent incident? That's your start date for the clock running on filing your charge of discrimination. So it's good to know that the employees have a short window relatively under the realm of law, 300 or 180 days to bring these cases. But again, it goes to the most recent incident. Not surprising. There's cases that have certainly held that before, but that's something to be mindful of. That the last incident is the one that's going to count as far as the time clock. The next case is about shifting reasons. Now, this principle applies federal law under all these discrimination statutes. So here's how it works. If I'm an employer and I let someone go and I give them a list of reasons and I document in my file a list of reasons, and they've filed a charge of discrimination with the EEOC, and I tell the EEOC that my list of 5 reasons, but then we get to court and now I'm listing 7 or 8 reasons, or maybe a couple of different reasons. That could be a problem for me, because what the employee is trying to show is that my reasons are really just pretext and that my real reasons are some sort of bias based on age, race, religion, etc. And I've had a case where this almost bit us, where it was the employer was trying to be nice, didn't list all the reasons at first, and then lists more reasons later. And the plaintiff attorney telling the court, hey, you shouldn't dismiss my case because their reasons changed. Now we argue, no, they didn't change. We just listed them all here. We only listed some of them before. Now we got that case dismissed, but it was a close call, and the same case may turn out differently next time. So the lesson here is, in this situation, it was interesting. So it was a panel of people making a decision for termination. And the plaintiff got their case dismissed, but then hey, wait a minute, their reasons are different. But each person on the panel may have had a slightly different reason. That's okay. So if there's a group of 3 or 4 people making a decision because they each had a different reason, that's okay. That doesn't mean they're changing. In this case, that's what the deal was, and the case was dismissed and it was affirmed on appeal. But even if it's the same decision maker, be sure when you're documenting things to not try to be too nice. You don't want to be overly mean either, but make sure you're documenting as if, if there's 10 reasons, list all 10 reasons, because you want to make that argument later. You want to be able to have that thrown back at you that you didn't list all the reasons. So that would be at the administrative stage at EEOC, and then obviously in court, even in the person's file, even in the termination letter, you want to be thorough in your reasoning as to why, because you want to be able to use all those later. If those are the real reasons, you want to be able to use them all later. And we're going to get into evals later, and it's a similar principle. You want to be honest in your evals. So next case is something that's going to be relevant in COVID, I believe, and had to do with an adverse employment action. So in all these cases, if I'm going to say I'm discriminated against, the employer has to take some adverse action against me. So it could be demotion, could be suspension, could be firing, obviously. Now, what about revoking telework privileges? Could that be adverse? Changing the employee's duties can be sometimes. In this case, the employer revoked the telework privileges of the employee. The employee said it was because it was discriminatory, though, based on an impermissible characteristic. And here the court said, well, that's not an ultimate employment action. That's not an adverse action. And so that's good for us, right? As employers, we can revoke telework privileges and don't have to worry about maybe that being considered discriminatory. Now, it may not always turn out that way. Not every case is going to turn out that way. In this case, though, the revocation was temporary, and it was based on a specific and clearly articulated need to have the plaintiff in the office. So again, we still want to have good reasons for doing it. This is a good case to show that it's not necessarily an adverse action to revoke those types of privileges. But if you do so, it's better to have a reason than to not. So that was overall a good result, and that one's probably more likely than a lot of these things to come up as people come more and more back into the office. Let's see. So we talked about adverse employment actions, right? So here's another principle to keep in mind is constructive discharge. So what if you don't fire someone, but they quit? Now, most of the time for unemployment purposes, if they quit, you're in good shape. Same thing for discrimination. Well, if they quit, then I didn't fire them, so I didn't take an adverse action against them. Generally, you're pretty safe at that point. But there's something called constructive discharge, and it's just like what it sounds. It's basically you weren't actually discharged, but you might as well have been. And the way to think about it is that if your work environment is so intolerable because of the discriminatory or harassing behavior that any reasonable person would have quit. That's constructive discharge. Now, in this case, the employee was going to be investigated and possibly disciplined for something, and they quit. They said, "No, this is discriminatory. I quit. I'm out of here." Well, the court said, "Wait a minute. That's just an investigation and a possible disciplinary action. That's not going to be an adverse action. You weren't constructively discharged. Now, you may have been discharged after the investigation and after the finding, maybe, but you can't just do it just because they said we're going to investigate you. That's not going to amount to a constructive discharge." So that was a good case as well for employers. Be aware of constructive discharge, of course, but again, just because the employee says I was forced to quit doesn't mean they were in this case. I mean, they must have been worried about the investigation, presumably, but that's not what the court looked at. They just said, well, look, this isn't per se adverse. You may have come out fine, but that hadn't happened yet. Just threatening investigation of an employee is not going to be evidence or be sufficient to be constructive discharge. So next case, and this is the one that has to do with evals I wanted to talk about because this comes up quite often in litigation, is that in this case, and this is kind of surprising, the plaintiff got a merit increase in pay and then was terminated shortly after that. And then she sued for age discrimination and said, well, look, I just got a raise for merit, and then you guys terminated me for not just terminating me, but terminating me for declining performance. How do you square that? Now, in this case, it turned out okay because the employee's performance declined after and sharply after the period that was looked at for the merit raise. So let's use an example. If my performance in 2020 is really good, you give me a pay raise in January, said you did a good job this year, we're going to give you a merit increase. Then if I just fall off in the first quarter of this year, by now my performance is terrible and you let me go, that's the situation here. Said, okay, you got the merit increase, but your performance really was poor after that, so it wasn't inconsistent. But I see this quite a bit, is where people doing evals, performance evals, quarterly, semi-annually, or annually, and they're too nice. And again, you don't want to be ugly, but if the performance is bad and you're thinking about taking action, you want to make sure you document that because it can be used against you and often is. They say, hey, you're saying my performance is bad or my attitude's bad, but my evals for the past 5 years are all 5 out of 5. No mention of attitude, no mention of poor performance. So it worked out okay here because of the circumstances, but when our evals, we want to make sure that we're being honest. So again, good result, makes sense. The courts will look at that sort of thing. It's not just, oh, we got a merit increase, you get to go to trial. This case, she got dismissed. So overall, a good result. Next is ADA. So we talked about accommodations. This is a new case as well. Fifth Circuit, again, federal case, is the employee in this case had an injured back. In this case, counted as a disability. So the employee and the employer talk. The employee says, I need a reasonable accommodation. Again, we talked about this earlier. Okay, he says, I want to be moved to a different paid position that I can actually do with my back injury. The employer disagreed and said, I'm going to put you on temporary unpaid leave pending the receipt of a doctor's recommendation concerning your restrictions. Well, the employee got mad and sued. Now, what happened? And the court said exactly what we talked about earlier, saying, okay, he had a disability. You had the interactive process. You discussed it. We're good. The employee wanted one accommodation, which may have been reasonable, and the employer wanted another one. Maybe that was reasonable too. The court said, well, the one they chose is still reasonable, even if it wasn't the employee's preferred accommodation. So case dismissed. So the choice between two different reasonable accommodations belongs to the employer. So that's good news for us. So when we're complying, this can happen. Differing opinions about what reasonable accommodation to choose. The employer chose, the courts backed them up. That's how it's supposed to go. So a good example for us on how we should go about it and how the courts will generally protect us if we do. So next is wage and hour violations. So I want to talk about first thing is willful violation. This is again national law. This is federal law. This is wage and hour. So right, overtime minimum wage law. So there's a principle in these cases that have to do with whether your violation, if you did violate the statute, was it willful, and then you have a good faith defense to it. So let's say I'm an employer and I make a mistake and I thought I was complying with the FLSA, but I'm not, and I'm underpaying my guys overtime. Okay. Now, generally, the general rule is that the employees are going to get their unpaid overtime times 2 plus attorney's fees. So that's the normal. And generally, they'll get to go 3 years backwards. So the period they're going to look back is 3 years. From the statute of limitations be 3 years. Now, if it wasn't willful, then you get to cut that 3-year period to 2-year period. And on top of that, if you did it in good faith, they don't get to double their unpaid overtime or minimum wage, you just get their unpaid overtime. So you're significantly reducing the amount of liability by having these defenses. Well, how do you have these defenses? In this case, is a good example. The company relied on a Department of Labor investigator who told them that their tip policy, tipped employees, their tip policy was compliant. So they relied on that investigator. The employee sued. The court actually disagreed with the Department of Labor investigator, and they issued an order in the middle of the case saying, we think this is incorrect. And the court even backed it up and said, well, we think it's incorrect, but they actually were not willful, even though they kept that same policy after the court said in the case, it wasn't final yet, that we think it's not compliant. In this case, the court still shortened it to 2 years instead of 3 because they were relying on a Department of Labor investigation. Here's another way you can do this, and I've done this for clients a few different times. FLSA and wage and hour, this again, salary exemption, all these things are under FLSA. There's sometimes it's a close call. What do you do? If it's a close call, what you probably want to do, and you have a good faith reason for choosing, for instance, somebody to have a salary exemption where they don't have to be paid overtime, or maybe their independent contractor employee status, it's a gray area, and you want to, if you go to an attorney, so it could be Department of Labor or it could be an attorney, and you go to, if you have a Department of Labor investigator, talk to them, document what they say, and if you comply with what they say, you're in pretty good shape. But you don't want to just call them on yourself per se, but if you have an employment lawyer, sit down and go over the issue, the policy with them. And if you do, then I do this for clients, and I write a memo explaining why we think our policy is compliant. So even if they are sued, one, I think we'll win, right? Because we think it's compliant. But number 2, even if we lose, we've significantly reduced our liability because we're going to have to take 3 years and shake it down to 2. And then instead of doubling, we can, if we show good faith, which is again relying on a good faith reason, which would be the advice of an attorney, Department of Labor, that sort of thing, we can cut it in half. So we've significantly reduced the risk, even though we can't guarantee a result on day one. If we go about this process, we can protect ourselves and significantly limit our liability in the future. So in this case, they did that with the Department of Labor, and it worked out. They severely limited it, even though I think they probably end up losing the case. They significantly reduced their liability based on kind of keeping their ducks in order and going with that advice. So something to think about for FLSA compliance. Now, this next issue is a Fifth Circuit issue, so Texas, Louisiana, Mississippi only. This is a big deal. There's a lot of lawsuits. I always talk about this because there's lots of lawsuits involving this. It works like this in FLSA. If one employee brings a lawsuit against your company and says, I was underpaid overtime, for instance, okay, he can actually say, I was, and I think a lot of other people were too. And it's called a collective action. It's like a class action, but it's not exactly the same. The other employees have to opt in to join this employee's lawsuit. Here's the part that's been kind of problematic for employers for a while, is that when the employee files this lawsuit, it's been very easy for them to get the court, believe it or not, to order that the employer give a list to the plaintiff attorney, basically, of all the employees that worked for them over the past 3 years who were paid similarly, with addresses and contact information. And what the plaintiff attorney can do is send a letter to these people. Again, the letter is approved by the court, but it goes to these people saying, hey, if you just sign this piece of paper and send it back, you're a part of this lawsuit. I've had it happen twice in the past 2 years, for instance, where a one plaintiff case turned into over 100 plaintiffs this way. So this is a big deal. This is the way it used to be. It's not like that anymore. And that's what this Swales case has changed. So it was plaintiff attorneys love this because now the settlement value just obviously went way higher with 100 guys or 50 people or even 10 people versus one person. The court changed that in January of this year and had a pending case about this. And the guys were from New York. And then when this case came down the next week, they said, well, forget it. Let's talk settlement. Very low value. It totally changed the game on these things. The court wasn't very specific about the full process, but basically that whole process I just described is out of the window. They're not going to make employer just off the bat turn over a list of employees that could join the case with contact information early on in the case for them to join. So that's all good for employers. These cases are not as scary. We'll see how it progresses, But that's a very, very, very good result for employers in the Fifth Circuit. I'm not sure if any other circuit will follow suit, but it was a big change. Most circuits do use that two-step method I just described, by the way, the old method. So I don't know if any of them are going to comply or follow suit, but very good news for employers. Those cases are a lot less scary than they used to be. This one's kind of comical. The next one, what if you pay someone a really high rate per hour? Does that mean that they're exempt from overtime? Well, no. So in this case, they were paying, the Martin case, they were paying the employee $75 an hour. Well, that's a good high rate, but it's not paid on a salary basis. And so to be exempt from overtime, you have to follow one of the exemptions. And one of the elements in most of the exemptions is that you're paid on a salary basis of a certain minimum amount. Now, salary basis means you get the same amount, regardless of the quality or quantity of your work. Same amount every week, right? Just exactly what you think of when you think of the word salary. Well, if you did his hours, of course, and you multiplied that $75 an hour times the hours of work, well, he was way above the minimum total pay, but it wasn't on a salary basis, it was on an hourly basis. Well, the problem with that is the court, of course, said, well, that doesn't qualify. Even if his duties are the type that would normally qualify for an exemption, you're not paying him on a salary basis. So you don't get the exemption, which is bad news for these types of folks, because again, a high rate employee, well, he's going to be paid time and a half for all the overtime he's worked. And there you go. That's sort of the problem with that. So obviously, if you have exemptions, review them, make sure they're paid on a salary basis, make sure they're paid the appropriate amount, and make sure their duties. And here's where most people trip up. Make sure the duties, I won't go into all that now, but all the duties that the employee is functioning under, or he's performing for your company, make sure that he or she is under one of the categories. Just because you pay them the minimum salary doesn't mean they're exempt. They also have to have certain duties, the executive exemption, administrative, professional, those sorts of things. But in this case, high rate doesn't do it, have to be paid salary basis, no surprise, but you do see this quite often. This is going to be a Texas-specific case. These laws, non-solicitation, non-compete laws, this does vary a lot state by state. In Texas, these non-compete agreements they can be enforceable. They're not impossible to be enforceable. They're kind of hard, but if you do things around the front end, you can have them enforceable. In this case, so the first step in Texas, by the way, is to have it as a part of another agreement. It's called ancillary to an otherwise enforceable agreement. In other words, you have an agreement and it's not going to be just a part of it. So here's how it doesn't work. An employee agreement that the employee is at will, generally not going to work, because you could fire them and they could quit any moment. So you're not really bound by anything. But if you have an employee agreement that says we're going to hire you employee for at least a year and then maybe renew, and if we terminate you without cause, we have to pay you a severance. I mean, that's okay. That could be an agreement that a non-compete could be a part of. Well, that was the case here. So it was enforceable, but in this case, it was a non-solicitation agreement. So non-solicitation means that a normal non-compete would be, for instance, you can't work as a lawyer in Smith County for 2 years. Okay, that would be normal. A non-solicitation would be more like you can't contact any of the firm's clients for 2 years. So you can't solicit the company's clients or customers. In Texas, they're treated the same. Those two non-solicitation, non-compete. The rules are the same. Normally, and this is something to think about, normally in Texas, you cannot restrict an employee, former employee, from soliciting all of your customers. You could generally only prohibit them from soliciting the customers that employee dealt with. So if I'm a salesman for you, you could say, hey, you can't, if you have an agreement, of course, right? You can't solicit any of the customers that you worked on for me, but you can't say you can't solicit any of my company customers, no matter who the salesman was. In this case, it was actually allowed to be broader than that. Here's why. The guy in this case was an executive, was a VP in the company. So the court said we're going to allow a broader restriction, which in this case was you can't solicit any of the company's customers. And the reason why is because he was much more than a salesman. He was an executive. He had intimate knowledge of the employer's confidential business information and trade secrets, more so than other salesmen. So it works the same way with the sale of a business, by the way. That's the broadest restriction that generally allowed. If you're selling a business, say, I'm going to sell you my business, but you don't want me to compete against you as soon as I sell the business. Well, you may have a statewide. I've even seen one that had a nationwide, in our case, nationwide restriction on competition after the sale of the business. The courts allow broader restrictions there because of the type of transaction. So think of it this way. You have a salesman, kind of narrowly tailored to kind of where he worked and who he did business with, whether it be his customers or clients or the county he worked in. Somebody more higher up in the company, maybe like a VP or an executive, you can have it more broader than that, kind of more where the company does business, regardless of where he does business, all customers versus just his customers. And then you have sale of business, which you can be a lot more broad. But in this case, they allowed it. It was more broad because he had higher duties. So if you have non-competes, review them. It's better to get around the front end because they're hard. once it's signed, it's gonna be difficult to change anything unless you amend it. And I won't get into the details, but especially before the person starts working, we have more options than once the person's already been working. In this case, though, I think the court did the right thing, applying it as you would expect based on prior law. So again, overall good for employers. They enforce the non-solicitation agreement in a broad sense because of the type of work this guy was doing. Okay, vicarious liability here. So this is obviously means when the company is liable for something the employee does. So in the first case, this one's interesting. It's kind of unavoidable. And this law is going to be very similar. All states are going to have very similar rules and laws on this. Even though these are Texas cases, this will be very similar in your state, I'm sure. But in this case, it was a police officer on call, driving his vehicle. He gets a call. He reaches down for the call. He gets in a wreck. The person he runs into sues him and I believe city of Houston for the wreck. The city says, well, hey, he's on call. He's not in the course and scope of his employment. I'm not liable. The court said, actually, he was reaching down for a call that could have been a duty call. When I don't think it was. It could have been a duty call. Therefore, we're going to hold the employer, the city, vicariously liable for his accident. Kind of unavoidable. This is one of the bad results, I would say, for employers this year. Now, again, with on-call employees, going back to FLSA, be careful with what you allow or restrict them to do, because you have too many restrictions on what they can do. In their on-call time will turn into a compensable time that you owe them money for. So I don't know what the police could have done here to prevent this, to be honest, the city of Houston, but something to think about. The next one is scarier, and it turned out better for the employer. So here it was a home installation technician who actually sexually assaulted a customer in their home. The customer sued the technician and the company. The company said, hey, he's not in the course and scope of his employment. We're not liable. The court agreed. And even though he gained access to the person through his employment, he wasn't in the course and scope of his employment. And so that's what you would expect, but that isn't, that's a scary situation. You have people going into other people's homes for your business. This is a good result for you to say, hey, look, if they go way out of bounds with this kind of craziness, they're not going to hold me liable for it. So this is a good case. Interestingly, also, the customer brought another claim against the employer saying he was negligent hiring this guy and training this guy, which are the different bases of liability: negligent hiring or retention and negligent training. Well, in this case, there was no evidence that the company was negligent in hiring this guy. And in other words, there's no reason to expect he would do this sort of thing, or they were negligent in training him. So the case got dismissed. It was good for employer, but it could have been a scary result, right? Because of sexual assault, the damages resulting from that, or not something you want to have on your company's docket sheet here. Next one is workers' comp. This is going to be Texas specific, guys. Sorry about that. But so in Texas, you have the ability to either subscribe or not subscribe to workers' comp. It's up to you. But if you don't, there's certain things that you lose, some defenses you lose if the employee sues you. Here, the employee got hurt, and the employee actually died in the first case here, the Harris case, and his surviving relatives brought a death claim. Now, there's an exception. Well, in Texas, you have to, if you have a workplace injury and the employer has workers' comp, you have to go through workers' comp. You can't bring a separate lawsuit. It's exclusive remedy. You got to go through workers' comp. Here, they tried to not go through workers' comp, and they said, well, and one of the exceptions to that, the mandate you go through workers' comp is that if it's an intentional wrongdoing of the company, or if it's this is kind of complicated, but if it's gross negligence and it leads to the death of the employee, and it's the employee's spouse or children that are bringing the suit. Here, the employee didn't have a spouse or children, so it's relatives who weren't a spouse or a child. Kind of complicated, sorry. But the overall aspect of this case is they wanted the court to say, look, it's not just intentional acts of the company that allow us to go outside workers' comp and sue them. We're asking the court to make it reckless as well. So in law, you have kind of intentional, which is like you did the act and you intended it for it to happen. And then you have knowing, which is not as bad, but you did it and you knew it was going to happen, even though you didn't intend it. Reckless is below that. It's above negligence, but below intentional and knowing. So you had conscious disregard for the risk, basically. You acted recklessly. The court said, even if the employer is reckless, you have to go through workers' comp. So good result for employers, of course. Odd set of facts. Hard to imagine that would happen exactly like that again with him not having wife and kids and reckless behavior and good evidence of it. But even if the employer is reckless, they still have to go through workers' comp. Again, just more workers' comp protection for companies. It was not expanded. The exceptions were not expanded by the case here, by the court here for reckless behavior. This next one's very interesting. So you had an employee, and this is the Texas Mutual versus Mendez case. So here, if you have workers' comp, if the employee is intoxicated when they have the injury, they're generally not going to get their benefits. And it says, the labor code even says, if the accident occurred while the employee was in a state of intoxication at the time of the injury, then they don't get their benefits. Here, it was a crushed employee. He died, unfortunately. A drug test was done on him after his death, and it found that he had marijuana in his system. You say, well, that's it. He's going to lose, right? Actually, he won, and here's how. The deceased worker survivor got another expert to say, actually, that drug test you did on the person after they were deceased is unreliable. It's not going to be accurate. And they had other employees testify that the guy didn't seem to be intoxicated at all at the time of the accident. So it actually, even though there was a drug test showing marijuana use in this case, he was allowed to get his death benefits, even though he had it maybe in his system. So odd set of facts, but it is possible. So let's see here. We have a few more minutes. So I'll cover FMLA really quickly, and then we can wrap it up. I have another one I'll cover really quick. I have it in my notes. I didn't have it on the slides. It's something to keep in mind is workers' comp retaliation, right? So if somebody makes a workers' comp, files a claim, says I was injured at work, be careful not to retaliate against them. In the case I don't have in the slide, I have in the notes, somebody made a minor complaint. It was assigned, they didn't get any benefits, but there was assigned a case or a claim number by the workers' comp insurer, and they were on light duty. And then they brought a suit for retaliation based on making the claim. And so if you're going to take adverse action against somebody, make sure it's not because of, or doesn't even look like it's because of a workers' comp claim filed by someone or complaint made about a workplace injury. Anyway, I won't get into details of that case, but that's just something to be mindful of. It was a result that was not good for the employer, but nonetheless. So last thing I'll talk about is FMLA. Again, if you have 50 or more employees, then this applies to you. And it's a federal law, so it's all states. Here's what happened here. So if you deal with FMLA, you know I can't retaliate against somebody for taking FMLA. Also, I can't interfere with their leave. Here's what happened here. Now follow this. This is entertaining in a way. So you have one employee. Let's say employee number one takes FMLA leave. Employee number two gets mad because he has to help out and fill in for employee number one while he's gone. And he's hostile to the employee that took leave. Well, the employee that took leave then complains to the boss and says, hey, employee number two, he's being hostile to me because I took leave and had to fill in for me. The boss fires employee number two, the one who was complaining about the first one taking leave. Okay. And then, well, that's okay, right? So nothing bad's happened to the one who took the leave yet. Well, then a manager of both those employees gets mad at the employee who took leave because he got the other guy fired, and the manager liked the other guy. And so then he started treating the person who took leave poorly. And the person who took leave filed suit. I hope that you follow the bouncing ball there. So you have an employee who took leave, another employee got mad and complained. The boss fired the one who got mad at the one taking leave, and then another manager got mad at the one who took leave because he got his buddy fired. Well, they brought the lawsuit. The court said that this is not retaliation. Even though the manager is taking adverse action against the one who took leave, it's not because of FMLA leave. It's because of it. It's 1 degree removed, in other words, right? So he's mad about this other employee getting fired by the boss. He's not mad at the guy for taking leave. The first guy who got fired was mad at him taking leave, but he was just a peer anyway. He didn't have any authority over the employee who took the leave. So anyway, good result for employers. Retaliation is something to be worried about. But even if adverse actions take place, it doesn't mean that it's because of, in this case, it's sort of close, but not quite. So I'll wrap it up there. I think our time is about out, but I appreciate your attention. Hopefully that was interesting. Overall, mostly good results for employers, a few bad results. But and the COVID stuff, again, it's continuing. The vaccine's probably the most pressing thing, but a lot of these things like FFCRA, et cetera, are kind of fading away, and hopefully we get back to normal soon.
All right, Eric, thank you. We do have a handful of questions real quick. So we're going to rifle through them and be kind of as direct maybe in answering them as possible. Susan asked, when you were talking about FMLA, 50 or more employees, you mentioned something about radius. Can you expand on what that was briefly?
Yeah, so the 50 employees have to be within a 75-mile radius as the crow flies, as they say. So you draw your circle, right, based on your locations. I've had customers, believe it or not, clients that have enough, they have 75 or more employees, but there's no 75-mile circle that there's 50 in it. It can happen, but 75-mile radius.
Sure. Next one. Can you explain a little bit on the term hearsay? Does this also apply to supervisors or managers who are disciplining employees and writing them up based on hearsay and not getting the side of the story? And what are potential ramifications there?
Yeah, so I mean, hearsay is a rule of evidence in court, is that basically I can't have someone testify about something they heard, that they just heard, right, outside of court. But in the workplace, there's no such rule. But to the questioner's point, it's better to go, if if you have an employee saying, I heard John say this, you need to go talk to John and document it. That's just good practice. There's no hearsay rule per se in this sort of thing, but I think you're probably talking about the one where the guy did as an independent investigation. He didn't rely on the biased Cats Paw manager. So it's best not to. It's not, there's a rule that says you can't, but it's best not to. If you can avoid it, it's best not to.
Okay, we got a couple more here. When you talked about the collective action process, can the employee who brings the action up be the one to basically recruit others to join the cause, or does it have to go through the courts, as you said?
Yes, so the employee can. The employee can, and they still can, just like any, I mean, they can bring them 5 together, right? They can even get together beforehand. But they're not going to make the employer turn over the list. But the employee can go out and try to recruit himself, yes.
Okay, I think we got that one. And let's see, we got another one just came in. Okay, so lots of acronyms on this. So on the FFCRA, could the 10 days paid use time or PTO time, or was it required to be in addition to allowed sick time and PTO? Is it,
yes,
does it come out of that pool, or is it a different pool? I think is what.
Very good question. And no, you can't. Yeah, you cannot. It comes out of its own pool. You can't make them take PTO concurrently. You can do that for FMLA. You can't do that for this. And I should have mentioned this earlier, Coleman. That 80, if you're voluntarily complying with FFCRA and somebody's already used their 80 hours for the 2020 and then now it's 2021, that's going to reset on April 1. So even if I'm an employee and I've used all 80 hours, April 1, I get a new 80 hours, and you can, again, don't have to allow me.
Okay, Leslie, I hope we answered that. I think I read that correctly in using different pools of time. So yes, thank you. I got a thumbs up from Leslie. So if anybody else has any questions, we got about 30 seconds here. If you'll type them into the chat, that would be ideal. Otherwise, we're going to have the, okay, I sure will. Otherwise, we will be taking this webinar. We will be posting it to our YouTube channel. We will be sharing the link with everyone. So that way, if there's something very specific you wanted to rewatch, you can do that. Eric, if you will share his slides with me, we'll put a secure Google Drive link in there where you can download the slides. I know one person earlier in the chat was using this for her CPE credit. I don't know what that is, but that's awesome. So thank you, Suzanne, is using that. So that's terrific there. We have a couple of people saying great presentation, etc. I won't stroke your ego too much, but we appreciate you for that. So, and the answer, Susan is asking for the shredding date. It was June 19th. That's a Saturday. Yes, I understand it's Father's Day Saturday, but that is the way it works. So bring your kids out and get your documents and stuff destroyed. But other than that, folks, we do appreciate you for joining us. What is June 17th? That's a Saturday. That'd be a Saturday. Lynn Littlejohn says, thank you so much. Thank you, Lynn, very much. We're going to wrap it up here. Everybody, we appreciate you. Eric, we appreciate you guys. Again, you'll be getting a link. So if you want to share, if you want to send to your ABs maybe to watch, or if you just need to reference something, we can do that as well. Susan, the shredding event is on June 19th. The shredding is on June 19th. That's a Saturday. Should be a Saturday. Other than that, folks, I'm going to end on the presentation. Eric, we appreciate you. Everybody, we appreciate you. Y'all have a wonderful day, and God bless everyone.